Okay, thank you very much for being here. Welcome to the panel on AI and work about how collective agreements can perhaps help that bridging the gap between what's happening really at the workplace and what the AI can do. So I would like to welcome the panelists who have been flying all over the world, literally, to come to CPDP. I will do it in alphabetical order, just not to make it easy. First of all, Claudio Agosti, here on my right. He's a professional programmer and information security analyst, and he's a founder of the Hermes Center in Italy. And then we have Lisa. Lisa here on my left, Lisa Krieske, a research and policy associate at the University of Berkeley in the US, at the Center of Labor Research and Education. Then here in the middle, we have Clara Helming. She is a senior policy and advocacy at Algorithm Watch. Then we have Isabelle Bartré. I'm very sorry, B is before Lisa, but it's okay. Isabelle Bartré is the Deputy General Secretary at the Trade Union Industry All here in Brussels. And last but not least, Mrs. Rebecca Smith, who is a workforce and policy executive in IBM Europe. My name is Aida Ponce del Castillo, and I'm a senior researcher at the ETUI, which is the European Trade Union Institute here in Brussels. And the idea of this panel is to look at what do we have at the AI Act in terms of worker protection. We know that from the original text, the AI Act was quite slim. They didn't really mention the employment context except from the Annex number 3. The Commission has categorized various uses of AI systems to be of a high risk and described them in Annex 3. And then during the policy-making process, they discovered that the workplace has specific implications, basically because workers and employees are in a subordination relationship, which makes it difficult to bargain and to defend their rights. And the idea of some policymakers was to bring some of worker protection issues in the AI Act, even though it's not a labor law piece of legislation, even though it's not a rights-based piece of legislation. What happened is that in some recitals in an article number 2, the policymakers included the right, or recognized actually, the right to inform workers and the right to inform and consult workers, which is already a right given by various EU directives and regulations. Across the EU, of course, on labor law and on European Works Council. The right to inform, or the right to inform and consult, is normally should be exercised before AI systems should be put into the market. But well, that comes with the difficulties of having AI systems at the workplace, and for that, Claudio will tell us, well, this is the theory. Let's see practically and technically what happens when we are faced into this type of new scenarios. Claudio, please, you have the floor.
Thank you. Thank you. So let's focus on the problem. The AI Act is a regulation that is made to legitimize and define AI systems. When they arrive in the workplace, that is not defined in the AI Act. So we are also start to see if this regulation can somehow be helpful or not for workers' rights. For the subjects, we talk about employee. Like there are already some professional orders like a lawyer, architect, or doctors that are trying to understand how AI Act affects their life, but they are independent professional. They belong to a category. Instead, for workers, I mean people that have a contract with an employer. And the risk is that if the way AI system arrive in the workplace in a way that is not properly regulated, it can, in somehow, subsume the worker from their ability. It can remove agency and independency and autonomy from the worker, like making it a mere shepherd of a robot. can, in general, reduce also the ability of the worker to understand what's going on. Let's say one of the thing I like to say is that we should have a dumb tool in the hand of experts rather than a smart tool guided by people that don't know what's happening. No? Hollywood and the strike they made last year was an iconic example because that category, the category of screenwriter, understood that generative AI can learn from them, can potentially replace them, and it was a sort of existential risk for their category. But also other form of work can be impacted, just is less visible, is less clear how it's going on, how will it happen, and so there is not also a stronger resistance against it. Some of the difficulties. As first, in a workplace, you need to know that an AI system is arriving. And at the moment, there is no obligation for an employer to tell you how a system is made. I mean, even the definition of AI system is quite vague, because we talk about AI in the last years because we saw the chatbots. But the AI Act definition of an AI system is something that takes a decision based on statistics of the past, can be non-deterministic, can be deterministic. In general, system that already exist will be considered AI system, but there is not this ability to properly communicate it. You are not really obliged to communicate this to your employee. There is also classification complexity. Like in these 5 years, new regulation like the Data Act, the Platform Directive are entering in field. And properly be compliant with this new system, understand how you have to change your local process, your compliance system, how the system should be updated. Maybe some category will be put in a second priority. And then the way that the system is impacting the workforce need to be understood by the worker. And the compliance effort is mostly meant to define products, not to teach to the worker how to use AI tools. But, you know, in the last years, there was an experiment that was very inspiring. From the Norwegian data protection officer, there was a sandbox. The sandbox has been also experimented in Singapore and in Finland, but the Norwegian data protection officer made a great documentation about it. And the sandbox, in their case, was to call for startups and companies that are developing AI tool, start to run these tools into their simulated platform, talk with stakeholders, so understand who will be impacted, understand how other regulation will be affected, how this can be compliant, and was looking like an agency that is trying to coordinate all the people affected. And even if this was a nice example, then when you look at the AI Act, you realize the sandbox may not be that a solution. Because the goal of a sandbox is only test the impact in other law, in other sector of the regulation. The authority can accept what they want. So if the changes are happening in all the domain and the authority has less than 100 persons to handle all the AI high-risk application, unlikely can take all the kind of tools to be tested in the sandbox. Ambiguity is not clear exactly what will be tested. Red teaming means that you start to assume the worst-case scenario and you start to stress test the tool. But sometimes only documentation assessment may be enough for an agency. And talking with stakeholders like the worker or the end user is something that typically doesn't happen. Diversity. The goal of the AI Act, like every European regulation, is that if something gets compliant in a member state, it's also compliant in all the member states. But an AI system that normally is developed with some context in mind show biases when it's used outside of this context. So even if the dock and the boat, the cargo ship are the same in Sicily to Hamburg, maybe a tool made to assist people that are working on the docks will perform very differently because the political, social, and geographical contexts are very different. And variability is that software changes quicker. So maybe you have a certified tool, but then the next version that is updated at the next software update will not be certified, and so the certification is still valid. One of the theory is that if personal data of the worker is processed, then the worker can also use GDPR rights to understand what is the process that is processing their data. But not all the AI tools that impact worker lives use personal data. Like if a tool is organizing your day job, it doesn't process your personal data, but we still have a lot of impact in you. No? And transparency is another big keyword that is very often mentioned, but is unclear. There is interpretability and explainability that are the two keywords I would like to hear more often. Interpretability is when you start to understand how a model, and therefore perhaps an AI system, works, why it's behaving in a certain way. And when you learn it, means that you can decide, you can opt. Today I'm using this mechanism and tomorrow using another one. You can interpret, you start to understand how the AI system works and you know it a bit. Explainability instead is a keyword used in the technical development. So there are mechanisms that let you understand how a system is performing, but they are meant mostly for engineers, for developers. If you try to use the output of an explainable AI tool for worker, they will not understand really what's going on, and very unlikely this documentation will reach them. One of the theories that we should see is that union representative, so people working in the company that are the connection between the unions and the workers, are also the one that need to ask hard questions on AI. But to do hard questions, you need to be expert enough. Again, we are seeing that it's the skill shortage in AI that is missing. It's not that the theory is missing. And then there is another issue, the open washing that AI is facing. Besides that, one of the major actors is named OpenAI and make a fully closed product. In general, open source is something that we still have in mind as a mechanism that let people understand what's going on in the technology. They can change it eventually. They can inspect it. People can be held accountable because you understand how the process works precisely. In the AI system, this cannot happen. Even if the AI Act say that open source framework should not be held compliant because they are generic, we have to consider that an AI system is composed by many components. If one is closed, everything can be potentially unexplainable. And how those components are open is subject to a degree. It's not anymore a Boolean factor. It's not open or closed. There are many shades. And so even the way we perceive that a tool is under our control may not actually be. And that's why open is sometimes used as a keyword to show that it's made on your interest, but actually you are just a user. And then another aspect that we need to consider is that labor union can be the right representative to talk with the AI authority to understand which tools are used in the workforce and also negotiate with them which better compliance and test need to be put in the tools. But this requires, again, that labor union need to have this skill to inspect what's going on, take evidence, report the problem, and then it's not clear with which legal grounds they can do that, because the AI authorities, again, is meant to accept product, not really listen to a citizen. Okay, that was my quick presentation.
Thank you so much, Claudio. And now I would like to invite the rest of the panel to pitch 2 minutes, in 2 minutes, big ideas of how you react to this situation from your perspective. So I'll start with Lisa, and then Clara, and then Becky, and then Isabel, if you like. And then we open for some questions. Thank you so much.
Thank you very much. So I guess it's quite useful to understand a little bit of the US context, given that we do not have the AI Act or the GDPR. In fact, there's only one data privacy law in the US, in the state of California, that actually covers workers. And so workers do not have any data rights, nor do they have any rights related to technology. And so that really sets the context for how labor unions respond to technology. And so in their negotiation processes, unions are basically negotiating all of those basic foundational rights, as well as any negotiations about the specific technologies. And then in many cases, labor unions are also negotiating around, to some extent, what would be the sort of the sandbox context, but they're negotiating around the process of governing technologies. So that in the US is often in the form of a labor management partnership or a technology committee in which labor unions are involved in the process. And that can be a limited scope where they're just involved in the implementation and consultation of the technology, but that can also scope all the way to where some unions are actually involved in the procurement process and then ongoing governance. So in the interest of time, I'll pass to my colleague.
Yeah. Well, first of all, hello, and thank you very much for inviting me to this panel. My name is Clara. I work at the German-Swiss NGO Algorithm Watch. We're a human rights organization that looks at the impacts of technology on society and fights for a world where technology benefits all humans and strengthens democracy. Well, I would just like to start by commenting on Claudio's presentation, which I think very well showed kind of the limits of the explainability concept. And I would just like to add that I think it's not only difficult for workers to understand AI, in many cases it's also very difficult for the employers to understand AI because, or the kind of products they're using to monitor work, and organize processes, because in many cases these are tools that they're not developing themselves, but are buying and that are proprietary and where maybe they can't even get all the information they need. So how are then workers going to get that information? And in Germany, where I'm based, in Berlin, they have been rights for workers' representatives to get explanations about AI since some years, and there as well, like that is a barrier where kind of this whole concept kind of doesn't really work in practice that well. But I think it is really important because what this technology can do in many contexts is like diffuse responsibility and increase the power imbalance that is already there between the employers and the workers. Because, for example, you can break down like the whole working day into small tasks, which can isolate workers, keep them separated from each other, and make it much harder to do collective action. And that is what would be necessary kind of for workers to actually move into a place where they can co-determine and participate in AI implementation instead of the model that we have right now, which is kind of more after-the-fact risk mitigation. So an AI system is implemented, and then afterwards something bad happens, and you kind of react to it. So I think there is a long way to go before we are actually at a place where workers can co-determine how AI is implemented. Thank you.
Good morning, everybody. Thank you very much for the invitation here today. So my name's Becky Smith. I'm based here in Brussels, and I'm working on all sorts of policy issues around workplace AI for the company IBM. So in IBM, we've been deploying and using AI for many, many years. So we have a long track record in developing also governance frameworks around AI. And that includes using AI in the human resources space. So we also have a long experience in terms of how to deploy AI in a responsible, ethical, and trustful way with our employees. First of all, just on the AI Act, I mean, from the beginning of the debates on the AI Act, IBM very much supported the regulation because we feel that it is necessary to have those governance frameworks in place, but also because of the approach that the regulation takes, because we're very supportive of what we call precision regulation. So ensuring that the regulation is really targeted at the use cases where risk occurs rather than is actually regulating the technology itself. And I think from our point of view, it is predominantly the use case that determines whether risks are apparent, whether that's risks to consumers or risks to employees when you deploy an AI system, and also what the AI system actually does. We use the term AI, I think, fairly loosely, and sometimes we may be talking about AI, sometimes we may actually be talking about automation, sometimes we may be talking about algorithmic management, and the way that the AI system is used and what it actually does also has a huge impact on the kind of challenges and risks we may face as a company, particularly in the human resources space. Aside from that, and I'll perhaps come back to that in the next round of comments, we also believe that collective agreements can play a role. Of course, that depends on the industrial relations system, and I'm happy to explain in more detail in the next round about a collective agreement that we've signed in Germany, which is specifically focused on AI. That was an agreement signed with our Works Council in Germany. But it's also very much determined by the governance frameworks that companies put in place themselves around, of course, embedding data protection, privacy, transparency, explainability, so all of the issues that the previous panelists have talked about. And for us, at least, we have a very clear approach around transparency towards our employees to make sure that they know where AI is being used in human resources processes. So we have a set of fact sheets that are available to all of our employees so that they can see where AI is being used and where it's not being used as well, so that they have an idea when they're engaging in different human resources processes, whether that's learning or whether that's processes around promotion, compensation, that they know that an AI tool is being used and that they have some recourse to explainability there. We also do a lot of work around skilling AI, not only with our employees, but more broadly in the community, because we believe it's very important if we are going to deal with the challenges around AI and allow an inclusive approach so that everybody can gain from this technology, that people have the skills that they need to actually be able to use and understand that technology. Perhaps what I'll also mention a bit more in the next round is how we also involve our workers in the kind of identification and testing of our AI tools. It's really important to do that to increase trust. And it also allows us to really identify those business processes that would actually benefit from the use of AI and the ones that wouldn't. And we believe that asking our workers about that really helps us, because at the end of the day, they're the ones that are actually dealing with these processes and doing the tasks. So they often know best which ones would benefit from technology. Thank you.
Continue. Thank you. And well, thanks for inviting me today. So I'm Isabelle Barthès from Industrial Europe. Industrial Europe is representing workers in industry, energy and mining sectors. And collective bargaining is our bread and butter. This is, as Lisa said, this is how trade union regulate things at the workplace. Of course, we have legislation, but the role of the trade union is to defend workers at the workplace and also to make the best also of the introduction of new technologies. And when it comes to AI system, in our industry, we find it everywhere, be it when it comes to maximize efficiency, for instance, energy efficiency, predictability, for instance, for predictive maintenance, but also for improving reliability for quality control and labor productivity. What we see is that there is an increasing of digitization linked also to the green transformation. And increasingly also, it is implemented in order to deal with skill shortages. It's a major issue here in Europe. And of course, we see more and more AI used in HR management. The challenge, and this has been said also by Claudia, the challenge for the trade union is that most of the time it is, of course, not used alone. This is embedded into automated processes, a system, and workers do not even realize that AI is used, actually. So this is a big challenge for the trade union. It is when we are talking about the impact on AI, especially on the volume of jobs, but also on the quality of job, it's not really clear what's the net impact is, and this is why we are calling for shaping the AI and the implementation of AI at the workplace. And of course, for us, the key tool is collective bargaining. Of course, as has been mentioned before, information and consultation. But for that, what is really key is to be able to have access to the information. So the question of placing the social partners on equal footing is really important. And the question of the access to information, especially for the worker side, is a major issue. And this is why we are calling for the support of external experts, because workers are often not AI experts. It's also, I mean, this has been already said by Ida, what is really important, especially in connection with protection of personal data and preventing the misuse of personal data and trying to protect human dignity is the fact that we actually build some collective protection also via collective bargaining, because of course we're very proud in Europe to have the GDPR, but at the workplace asking for individual consent is actually difficult when you are in a subordination relationship. So, I mean, this is why we are calling for negotiation to build collective protection to ensure that personal data of workers are not misused. And well, there are examples. I mean, the one example from IBM is one. There are plenty of examples coming from Germany, but I guess we will come back to that in the second round of discussion.
So this is the scenario that we are living in normal companies with normal AI systems and workers that are exposed to that. Now, the AI Act is very slim on worker protection, as we already know, because it's not its objective to do so. I already mentioned that it includes certain keywords, and one keyword that you have heard is collective bargaining or collective agreements. I know that this is not a labor law conference, it's a privacy computer law conference, but collective bargaining is this tool or mechanism that has been recognized by the International Labour Organization and by the EU laws, by which workers and employers have the prerogative to make contracts between them. And these contracts are called collective agreements. These contracts are important because they can go further directives or regulations, and they can modify working conditions, wages, etc., including technology, the use of technology. Now, why is it important? Why did we want to do a panel at CPDP on AI Act and collective agreements? Because this is a way in which the AI Act can be further steered towards better application at the workplace. And we do have some collective agreements already in place on AI even before we had the AI Act. And maybe in this round, the speakers can tell us about the experiences of their collective agreements, what type of clauses are there that can be useful, and maybe Claudia can give an example of what type of information could be interesting for workers to deal with at the workplace. Let's start first with this side and then with Claudia afterwards. Thank you. Lisa, please. What's experience in the US?
Well, I should mention, I failed to let you know, so I work for the University of California Labor Center, which essentially is the public-facing arm of the university that supports the labor movement as well as policymakers in terms of developing policies for the workplace as well as inclusive economy. And over the last, since about 2018, I've been researching collective bargaining agreements. And there are a wide range of agreements that have really focused on digitalization historically, and then also increasingly algorithmic management, data collection through electronic monitoring, as well as HR analytics. So there's a long history of examples along those lines, but probably the most recent in terms of AI, the Hollywood actors as well as writers is probably the most prominent example. And those provisions are several pages long and very, very complicated, but some of the highlights, in addition to the foundational rights of data transparency as well as the right to know, they also, for the writers, have provisions for job security, authorship and professional status, which secures their compensation. So AI cannot undermine the writer's credit. They also have creative discretion and autonomy, so writers can choose to use generative AI or not. And they also have the right to seek recourse in the event that the employer decides to move ahead with generative AI. SAG-AFTRA is the Actors Guild, also has foundational rights, advance notice, right to information. They also have artistic control. So that essentially means that the companies must obtain clear consent from actors if they, including background actors, which is a really important issue for the Actors Guild, if they are going to create digital replicas or basically alter the actor's acting in any way, which is often what you see in games, gaming, as well as in any sort of science fiction type movie. And so they have control, and they must know about it and be able to consent over those alterations. And then also in terms of generating a synthetic performer. So the key to this is that they really have the right to be at the table to negotiate over how the AI is actually used and how it implicates in their jobs. And they also have autonomy and discretion, which is important.
Maybe Becky this time, would you mind telling us the experience of IBM collective agreement?
Yeah, sure. So we signed a collective agreement in Germany in 2021, which is really focused on AI. Just to explain a bit how it works. So basically, it creates a traffic light system. I think that's the easiest way of explaining it, to classify all of the AI tools that we use in the human resources space. So the more risky the AI system, the more information that workers receive about it, and the higher the level of explainability of the AI system and the decisions that it's supporting. I mean, this agreement was negotiated on the basis of our existing governance principles in IBM around AI, so everything that I said before about explainability, transparency, fairness, robustness of data, something we haven't mentioned so much yet, but it's a really key issue. And also a really important centerpiece of all of our AI systems that we deploy in the human resources space is that none of those systems take a decision. They're only supporting and augmenting the decisions that are made by humans. So this collective agreement is really centered around those principles. I think the benefit for management in particular was that we have one overall framework. Now, as you know, the collective bargaining system in Germany is a very specific one with lots of instances of different work councils and things. So this gives us an overall framework which helps us govern the use of AI tools in the HR space in Germany. And I think it also helps with a smoother process in terms of implementing those AI tools. Because at the end of the day, if you don't have the trust of the workers when you come to implement or deploy the AI tools in the HR space, that deployment process is much more complicated. I'd also mention that one of the other initiatives that we've been involved in, and in fact was initiated by a colleague of mine in IBM Germany, Lars Chatillot, is an initiative that brings together IBM with other companies, but also with scientific experts, HR management, academia. And I think it's also important to highlight that, of course, collective agreements play a role, but these kind of broad alliances of different actors can be really, really beneficial. And that's an initiative that's called Human Friendly Automation Initiative, which, again, really has as a principle at the center of it this idea that AI should be augmenting human intelligence and supporting humans in their tasks. Thank you.
Thank you, Becky. Maybe Clara, what can you tell us about this and your experience in Algorithm Watch, looking at many collective agreements as well?
Yes, thank you. I think Rebecca already mentioned that AI is kind of a very vague term that doesn't have one clear definition, and there are a lot of different kinds of technologies that fall under this term. So, of course, it is very important to look at the actual technology that is used in a company and kind of make an agreement for that, and kind of include workers in all the steps of implementing this technology, starting actually from like the problem definition, if we even need this technology or not. So I do think, of course, that collective bargaining agreements do have an impact, and Algorithm Watch has made some recommendations about that as well. But if we look at like the impact overall, like if you look at the whole labor market, then there are, of course, many, many companies that use AI technology, that use employer data, and that don't have collective agreements, and that where this is not going to have any impact because they're either not covered by trade unions, they don't, like in Germany, don't have a works council, like many companies don't. And looking beyond Germany, I think the situation, like it's even more like that. So of course it is a very limited tool, and if we look at where algorithmic management is used a lot, for example in the gig economy, where in companies like Uber or all the food delivery services, like the entire working day of a food delivery person is determined by algorithmic management, then I mean I wonder like how much impact it has overall, the collective agreements. They do, of course, for specific companies, but not for all workers. So I think we do need policy measures beyond that. It cannot be only within companies. And even within companies that have agreements, like recruiting was also mentioned at one point, so people who are not yet part of a company, but apply there, and are maybe rejected based on an algorithmic decision, like what kind of powers do they have? So I think there's a lot of limitations for collective agreements, even though they of course have a big value.
So, practically, what do we do at the workplaces? How is it possible to negotiate AI at work? Isabel, tell us your experience.
Actually, it's, as it's been said already, it's not so easy actually to identify what is going on at the workplace, because, I mean, you have very specific example like IBM, but there are not that many actually. So you have a whole range of agreements that are related to data protection, and a lot of these agreements in Europe are being concluded in Germany. I mean, it is linked to the legislation on data protection. And then it's quite clear actually. I mean, the agreement needs to specify the purpose of the new technology, the fact that performance cannot be monitored, profiling or automated decision are not allowed, change cannot take place by asking individual consent. So this is already pretty clear. The problem in Europe is that it exists in Germany, and what we see, and especially in European Works Council, because this is where these discussions are taking place. I mean, we had a recent case in ThyssenKrupp elevator, where the Portuguese colleague actually they were basically tracked with geo-tracking a tool. I mean, they actually call themselves the Pokemon workers. I mean, they really had the impression that they had actually no autonomy in their work. So they really tried to to actually regulate their possibility to move based on the German example. But this is not possible because there is not such law in Germany. So this is why at European level we are demanding a legislation on algorithmic management, because as you said, Clara, I mean, we need protection for workers, and we have actually prevent abuse practices. But there are also many discussions taking place in the context of the transformation of the job. For instance, the fact that you have the introduction of predictive maintenance entails a complete change of the job within the company, actually. And hence you have actually, and this was already mentioned before, I mean, you have to inform the workers what will be the impact on the job, what will be the impact on the skills that they might require. And then training also have to be organized, actually. So, I mean, it's, in a way, the tools are, I mean, at least in Europe, information consultation, negotiation are important tools, but also we need also the law to regulate some of the ethical aspect of AI.
For Claudio, more technically speaking, we have these contracts that employers and employees can sign and become binding. What type of technicalities can we put in this on them?
Thank you. Not only I want to answer on how the contract between employer and employee, but I also want to remember some of the experience shared by Clara and Isabel on how often is the employer itself that has no full idea on how the AI process is working. And the first important question is, am I buying a tool that I can run in my own infrastructure and will keep the data of my workforce? Or I am buying a service which perhaps will also be used to understand how my workers are performing, and behind the scene, this service is meant to replicate my ability in the long term. Because we saw that in the last 20 years, some of the digital products were also meant to infiltrate, study, and exploit, subsume existing business. So it's not different what has happened with Google News and the news media, that potentially now can happen also in other domains. So the first main question is where the data are going. If they stay local, that is an asset for the worker and for the employer. Then the other kind of detail that should be understood is which kind of data is processed. I mean, which kind of data is also one of the core aspects of GDPR. You need to understand what part of your expression is processed, and in the work process, which data are actually considered to give some answer. Because if you understand it, at least the day that something is not performing well, you can understand that it may be because of one of these inputs. I like to do an analogy like cooking something and the ingredients. You know that one ingredient is changed, the result is changed, you can attribute responsibility. But if you don't know what is getting in, and you cannot even judge what's getting out and understand if there is some link. That's why perhaps defining in a more programmatic way which data, how is stored, is not only part of the GDPR compliance, but can also be helpful to understand how those AI processes are impacting.
Thank you so much, Claudio. Is there any question at this moment from the audience? Is there any question from the panelists to each other?
I have one.
Yes.
It is mostly to Rebecca. I believe, I wonder if the effort of transparency you are making, is it something that IBM understood that was important to be done because it was fair? Or how much the fact that it's about human resources and HR, and everything about HR is classified as high risk? So I should expect that the lesson of IBM should be replicated by anybody else, because who use AI in HR function will be bound to the same level of transparency. But I don't know if you see that this experience can also be applied to other companies, or if something that has a different background of thought.
Yeah, so first to say, I mean, we had the principle of transparency way before the AI Act, so it's not a reaction to regulation. It's part of how we believe AI should be governed internally. And of course, I spoke more about the use of AI in human resources because we're speaking more about that here today. But of course, you know, we have a whole suite of tools that we use internally, which are based on AI in different business processes, and that our clients also use in their own business processes. And I think transparency is also a principle that we put across very much when we're dealing with our clients. So we have what's called an AI ethics board, which looks at our own internal IBM use of AI tools, but it also looks at the use cases that our clients are using our generic AI tools for. So we tend to have generic AI tools that clients then adapt with our support for their own use case. That's why for us in the AI Act, it's really important that you have this distinction between the deploys and the users, if I'm getting the words right there, but because we have a obviously different kind of responsibility if you're just providing a generic system than if you're actually deploying the AI in the company. So I don't know if that answers your question, but it wasn't a reaction to legislation. It's something that, I mean, that has been important for us for a long time.
Just, if I may, to continue, because it's also very important. I mean, in industry, the thing is, of course, you have use of AI in HR, but also in the production, you have a lot of AI, a lot of sensors, and you have a lot of data generated. And so far, these data were generated, but they were not always used, or what they were used for production, but they were actually not used to monitor workers. But now, actually, with the algorithm, of course, you can also process all these data. So, which means that from industrial data, you actually can monitor even further workers. But one question about the transparency and the explicability. How actually do you take in the IBM example the fact that the AI is actually is a learning process? So what you might, and where you say, well, you know, we actually put in place a process to ensure that we have some safeguard. How do you actually take into account the this learning process which is intrinsic to AI, actually, which is also a challenge for instance, for collective bargaining, because that means that you need to have regular check, actually, on how this is, whether the agreement, in a way, or the clauses are fit for purpose. So I don't know whether this is something that the IBM, because it's a very secretive agreement. Everybody has been trying to wanted to read the IBM agreement, actually, and so far we don't know about it.
Okay. Well, I didn't negotiate it, so I'm not going to go into that discussion. But I think, the agreement itself is fairly broad. So it talks about the risk level of the AI systems that you're putting in place. It applies to any new AI system that is being put in place in the human resources space, but also any substantial changes to existing AI systems. So that's one important point. But I think it's, as I said, I wasn't involved in the negotiations of that agreement, so I don't want to go into too much detail about it. But I think it is adequately broad to cover the different use cases. And it's not only about the potential risks that could be faced by deploying an AI system specifically in the human resources space, but also the likelihood that those risks would happen, because that's also an important thing, depending on the mitigating measures that you take, depending on the number of workers that are using those systems. The other thing I'd say about learning is you're completely right. It's, the development, the deployment of AI systems is always a learning process. And, each company may not get it right from the start. So what we do internally, and I'm sure a lot of other companies do that, is we do pilots, we test it with a small group of employees, we check to see if it's working. Sometimes it works, sometimes it may not work, and it may be that it's decided that it's not the best way to, improve a business process. So there is a bit of trial and error there, and we would always use ourselves as a company as client zero before providing that AI tool to our clients as well, so that we have an idea of the impact.
I would maybe actually come back to a point that Isabel, you made earlier about legislation on algorithmic management, which is a policy demand for kind of the EU, because since we all haven't read the IBM agreement, I think maybe going back to the more general topic would be interesting. So I think that is a very important point, because the algorithmic management is having an effect on kind of work beyond like software companies like IBM, which of course like IBM has a very strong incentive to develop their own policies around this as a company that not only uses it internally but also sells software. But there are many companies that maybe don't have this very strong incentive and are not in the spotlight for having good software in the same way. So I think it's very important to have legislation on algorithmic management beyond that, also to prevent something that I think happens, that is likely to happen every time you have a new technology, and that is that this new technology kind of strengthens the power imbalance that you already have and leads to workers' rights being eroded. This is something I think that we've seen in history a lot of times, and it's something that we can see right now, for example, through platform work, where even in Germany, where the labor laws are comparatively strong, and for example, it's not that easy as it is in other countries to have independent contractors working in the platform economy, we still see these effects of kind of platform work taking hold in more traditional workplaces. And I think that's something that we should be very careful about, and we should be very protective of the labor rights that we've earned in the past, and not give them up easily in this context, in this moment that we're in.
No, go ahead, honestly.
I just wanted to mention the importance of really having a process. So there's, an importance to have the foundational rights of information, consultation, and transparency, but then there's also the importance to be able to process through, have a governing body for workers to be at the table. And so some examples of that, the National Football League in the US has a standing censor committee. And so all of the biometric sensors that are used by on the players, which are many, are governed by this committee that enables the Players Association as well as the players to bring in outside experts that they can consult over these systems. And this is also really important moving forward for each time a system is reconfigured, or when a platform, so say an HR platform, acquires a new company, or a few years ago, or every year I go to the HR technology conference, and right after generative AI came out, the vendors were touting the fact that they were rolling out new manifestations of generative AI in their products on a daily basis, multiple versions of generative AI in their products. So having a standing committee to review these changes is really crucial as we move forward further into digitalization, which we're only partially in at this point.
Hi, my name's Paul Graham. I work as a DPO for a rather large telecommunications company. This is a really interesting discussion. Microsoft is pushing out co-pilots, amongst others, for MS365, the entire suite, plus Purview, Microsoft Defender. So you have two aspects. You have one where you have monitoring and surveillance, which is extremely granular going on in the background, which workers are not aware of because of security measures. And then you have the actual modules, the co-pilot modules themselves, grounding in Teams chats, transcripts, emails, content. This is happening now in, well, I say the majority of companies within the last 3 months that have received the licenses. And people are doing DPIAs, and you're absolutely right, it's very opaque. You can't get any information from Microsoft as to how these things actually work in algorithmic management. But there are two points here that occur, and which the unions within Sweden certainly are addressing to us. And that is, there's a right to use systems both in ordinary trade union activities provided by the employer, which includes Outlook, Microsoft Suite, because it's the infrastructure. But these are now being logged and indexed 24 hours a day, 7 days a week. How do you see that problem? And then from an employee perspective, it means that personal use now is effectively not allowed within the systems if the employees want to give specific sensitive data about their personal lives separate and not logged and indexed by the LLMs. And then I have a second question, Rebecca, to you, right? So multinational enterprises work in strong matrix functions, and they always start with Germany first approach because of the Works Council's co-determination rights. Do you have a differentiated approach for how you deploy your AI systems for HR and employees? Or do you have a global approach? Do you take Germany because it's more strict and then apply it globally? Or do you differentiate between the jurisdictions?
Yeah, well, I'm happy to take the first question. Thank you. I mean, it's actually very well spotted. I didn't plan to discuss it here because I thought this very much trade union business, but the question of digital access to workers really exploded during COVID, and it's still here. And the way it's been dealt with in many countries and companies is through agreement. And in Germany, in our chemical sector, there is even an agreement that has been negotiated on how to secure digital access for trade union, because I mean this is essential also for democracy at work. Of course, the GDPR now plays an important role, because in principle, I mean some companies are trying also to misuse the GDPR to prevent trade union to access these data actually. So I would say in most countries, even in Norway, the issue has happened everywhere. The problem happened everywhere, but was mainly solved via agreement. So I'm happy at the break even to share with you some, give you my business card, and then you can send you example.
Thank you. I want to interact with the first part of the question about the tools that are imposed in workers. I mean, my answer is dual. The first is that it's a shame, because every time you get imposed to use a tool that exposes you to more surveillance is a problem. And when it is something like your hospital or your collaboration with your interaction, with a labor union, that is also Article 9, the particularly sensitive category of data. It really is a problem. But it reminds me when during the beginning of the pandemic, there was the rush to have technologies to do remote teaching. And you see that the maturity of tools under your control was inadequate compared to the one of Google and Microsoft. And that is a problem for the digital economy of Europe. And it's a problem that even if there is effort to challenge it, we are in a clear situation of monopoly. And who decide those tools always find himself between, should I take the tool that give me control of the data, but is slightly less better than the monopolist, or not? And the UX, the support, the localization, those kind of, the usability are always values that are considered more than actual control of data, sovereignty, and ownership of the infrastructure. And that is a cultural problem. We can change it only if we keep bringing ownership of data, privacy, and control of those elements as a primary feature. And we require years, because we have to win against other strands.
Thanks for the question. So clearly our governance frameworks around AI are global. I mean, our CPO has a global role, our AI ethics board that I just mentioned has a global role, all our training commitments around AI are global, so that's clear. But at the same time, of course, we, like you, I'm sure we have to adapt to the different legal frameworks, whether that's privacy frameworks, whether that's social rights frameworks, which are very different for a global company operating in different jurisdictions. And I would say also the industrial relations system is very, very different. You mentioned you're from Sweden, very different system to Germany, to Romania, wherever else you want to talk about, and that's just in Europe. So yeah, of course, we have a kind of basis, a global approach for all our workers and all our AI systems, but like any global company, we need to adapt to those different rules, regulations, and I'd say cultures and practices as well.
So we are always talking about, as multinationals, we're always talking about global processes. So we're always talking about global DPIAs. So and DPIAs should very much be a part of the assessment of the deployment of AI modules, particularly co-pilots in the workplace. But it's not really global. It's global, because you have this, you have the principles at the top, but then you always have to check against the individual employment laws, right? And we have differences there between Finland, Italy, France, Germany, Sweden, Norway. So yeah, I understand the difficulty, but it always comes down to cost. There's a temptation that leadership teams say, it slows down the deployment of certain systems by going through the consultation programs. So they deploy globally. They don't want the extra cost, particularly if it's a lengthy co-determination process. So I agree with the panel before that, you need the regulation, you need clarity on this as well. And it would be really good from a data protection perspective if there was an update to the WP29 guidance for the employment relationship, which, it really needs updating. It's from 2017.
Yes, thank you so much. There is another question over there, please. Thank you so much. If you have a question, please just introduce yourself as well and just raise your hand.
Thank you so much. I'm Gaya Meyers. I'm with Women in Development Europe. And I have a question specifically on the EU proposals for EU regulations, and specifically how can we ensure compliance? Like, should we have public bodies, and how can they access data? How can they then control companies? So how can you practically, it's not there yet, but how could you ensure compliance? And also, how can you do that on a global level, for example, with ILO conventions that are used also in trade agreements for core labor standards? Should there be something like that for, as a worker rights on how your data is protected, how you can manage your data as a worker?
I'll say something. Well, you mentioned something very important, which are ILO conventions, and which many countries have adhered to them, and they are binding themselves in bringing these ILO conventions into sectors and into workplaces or companies. So there are high-level principles that are agreed between ILO works in a tripartite basis. So between employers, governments, and employees. So all the three actors have said, yes, we want this, and we commit ourselves to respect them. There are plenty of ILO conventions. The first thing to do is to perhaps go to a company or to a multinational and say, well, by the way, how are you implementing the ILO that your country signed in the 90s or in the 80s? Where are your principles? How are you translating that into actual collective agreements with your workers or within your sector? This is one way. For the AI Act, I think it's going to be very tricky because the AI Act is not part of labor law, and it's going to be implemented by authorities that are not used to inspect workplaces and see whether working conditions are being respected, or see whether recruitment processes, which is not part of the labor context, are being respected too. So I don't know. This is why we do this panel, because we also want to find some answers to that. But I think that both employers in companies and employees in companies have to be aware that the AI Act has to be implemented, and both of them have sort of a role and responsibility in trying to make things work at work. Employers need to comply with the standards or with the obligations, and employees have an opportunity to oversight that employers are actually doing that. So I think that despite all these terribly issues on the AI Act, and you know how it works, I think that there is an opportunity of employees to push for whatever compliance can be there and ensure the cross-fertilization between the supervisory authorities, maybe labor authorities, data protection authorities, equality bodies, all these actors that have some power in governing need to take into account the whole dimensions of AI. And one is this labor aspect. And again, now that you have thought about the answer, maybe someone can jump in.
I only have like one small addition to that, and that I think enforcement is, of course, like very difficult. We see that with GDPR, which also has some implications for workers that are very hard to enforce and implement. But one important component would be to strengthen workers and to strengthen workers' representatives, to give them more rights, to give them to strengthen collective bargaining, make it easier for workers to move against this power imbalance. I think that is one way that we could strengthen enforcement.
Well, I mean, yes, the AI Act is a hook, but it is not about employment regulation. I mean, it's about market regulation. I mean, there is this obligation to inform about high-risk AI, but it's only an obligation to inform. There is no obligation to consult, and this is actually very important for us, which is actually now in the legislation on platform work, and we see also interesting opportunities there to strengthen workers' rights. Unfortunately, for the moment, it's only limited to platform work. Another aspect that I'd like to stress is the AI Act also has an obligation to train. I mean, employers that are deploying high-risk AI have to inform their workers. And we find that very important because this is key actually to ensure the human in control principle. But the question is how this is going to happen in practice. So maybe we need more enforcement legislation.
All right, and there, oh, sorry, yes, Becky, please.
Sorry, I just wanted to rebound off Isabel's final point. I think we really need to, first of all, see how the AI Act is implemented, transposed, including in the employment space. I agree, it's not a piece of worker legislation, but it classifies a lot of what we hear are the high-risk uses in the employment context as high risk. So I think what we need to do first is to see how is that legislation implemented, and only then should we be thinking about where are the gaps. And if we are going to think about where are the gaps, we can't put to one side all of the other social legislation, whether it's legislation on health and safety protection, information and consultation, non-discrimination. And I think what we need, before we go ahead with new legislation, is a much broader debate on how does all this social legislation that was adopted decades ago, how does it fit and how can it be enforced in a very different world of work? And we need that kind of substantial debate before we start deciding, okay, do we need one piece of legislation on AI in itself? Do we need another piece of legislation for platform workers? Do we need another piece of legislation on X, Y, and Z? We need a much broader debate first about whether that legislation is fit for purpose and how do we enforce it with a much higher prevalence of digital tools, whether that's AI or anything else in the workplace. Thank you.
Interesting point. I will come back to that. But first, let's take the two questions that are hanging there. Let's take the two of them at the same time, and we can respond to them. Please, go ahead.
Yeah, thanks. Good morning, everyone. Marco Morgan with Workday. We're a software company also with applications in the HR space. We've talked a lot about the governance, the complex governance structure, the preparations, hopefully by organizations to comply with all these legislations in the future. But I'm looking at something more short term. What can organizations take, let's say in the next 6 months, to say, we want to do something, what can we do? Is transparency the right way? Should we adopt a risk-based approach to how we're thinking about using AI? Should we have more clarity maybe around how we're using data internally if they're already not because of GDPR? So if you have any I don't say simple, but immediate ideas that organizations, and again, I'm not thinking only about companies, but what about public sector organizations as well, governments, what can they do to try and improve this in preparation for those regulations in the future? Thank you.
Second question. Thank you so much. In the meantime, please, panel, yes,
sorry.
please go ahead.
My name's Aparna, and I work at AWO, which is a data rights law firm and consultancy. I have a quick question just on whether any of the panelists have reflections on the Platform Workers Directive and opportunities for AI governance in the workplace there.
Can we allow one more?
Hi, my name is Timothy, and I'm from the Netherlands. I have a question. Thank you for the insights, first of all. I'm hearing a lot of concerns about the implementation of AI in the workplace and specifically for workers. But a couple of years ago, the European social partners have, how do you call it, drafted a European. Oh, pardon. Well, yes, there we go. The European social partners has drafted a European social partners agreement framework for digitalization, because the co-determination process across Europe is very differs per member states. I'm wondering what should this conversation about AI and how it's implemented in the workplace be discussed at the European social partners, or should I'm just wondering what you guys' opinions is about that.
Thank you so much for those very interesting questions. We need quick responses because otherwise the panel will close. Please, Lisa, can you start? No? Well,
Go ahead.
let's take on the other side. Thank you.
Can take the agreement on digitization, which was negotiated in 2020, which I think is still extremely relevant for the debate we are having here. One of the difficulty with this European framework agreement is their implementation on the ground. I mean, in some countries we see things moving, but in other countries nothing is happening because the social partners at national level refuse to implement the agreement. I think this is a shame because a lot of what we've been discussing, we didn't have the AI Act at the time, but still a lot of the very important principles are there.
I would maybe respond very quickly to the question, what can companies do in the short term? I think the first thing would be if you're implementing some kind of digital system, some kind of tool to check what are the criteria you're basing this on. Is it only about like making the process more effective, which is of course the first aim, or are you also looking at how does this affect employees? How is their data used? Who is responsible in case something goes wrong? And how can workers kind of give their voice to this implementation? That would be a quick response to that.
I would add to what Clara said and actually take it one step further, which is involving workers in the problem definition of what technologies need to be acquired. And that is critical because they're the experts. I mean, it depends on the type of technology you're talking about. If you're talking about an HR technology versus a production task type technology, workers are the experts on the front line of those technologies, and so their participation in that decision making is really critical. So I would think that I mean, if you're obviously companies have a certain amount of budget for technology, what's going to be the most valuable technology for that company?
If anybody has anything to say, I would like to thank you for your questions and your interest in the panel. And thank you, of course, for all of you for being here. Have a rest. Nice of the conference. Thank you. Goodbye.